Is there anything more misunderstood than the attorney-client privilege? It's not a magic wand. Today on Zippy Point.
Quick Zips by Zippy Point.
Quick and dirty. I'm Brock Romanek, and I'm a big fan of use. The attorney-client privilege is confusing. I'm one of those. I'm not an expert, but I'm making this video anyways to tell you that I'm not an expert. So the attorney-client privilege protects the client from disclosure about communications to third parties. The communications must be confidential between the attorney and the client and made for the purpose of obtaining or providing legal advice. Those are the three prongs, and all three of those prongs must be met for the communication to be privileged. The purpose of the privilege is to allow clients to discuss issues openly in order to obtain legal advice from both their, if they're in-house counsel or outside counsel, without fear that those communications will be disclosed to third parties. And the parameters of the privilege in a particular situation depend on the law of the state where the communication took place. So the test for whether a certain communication, a certain email, is protected by attorney-client privilege consists of a subjective part and an objective part. The communication must be subjectively intended to be confidential, and that intent must be reasonable under the circumstances to expect the communication to remain confidential. So the subjective test is easily satisfied in the email context because it's presumed that if a person is emailing their lawyer, they intend that communication to remain confidential in most cases. We'll come to an exception soon. In the email context, the objective test can be more complicated. Can someone reasonably expect that their email will remain confidential? What if it's an outside director that still works, they're not retired, and they use their day job's email address so that email travels through their employer's computer servers and is saved on their employer's electronic files through the routine backup process that companies have. So this Wachtell-Lipton memo states that it's clear that not only that electronically stored information is explicitly required to be produced in discovery if there's a lawsuit under Delaware law, but also that if a director uses their own work or personal email account for anything related to the board materials, board communications, those email accounts may be subjected to discovery in litigation. So if a director conducts board business using their work, their external business email, those emails may be subject to routine or litigation-driven searches and reviews related to their day job, their full-time workplace. And so even though litigation might be unrelated to their service as a board, these searches could compromise the confidentiality of the information and then call into question the attorney-client privilege that the director would seek that otherwise might have applied. That's a problem. So I love Adam Epstein's blogs, and this one really brings home how directors unwillingly waive or destroy their attorney-client privilege all the time, as he states in his blog. He notes that copying your emails to counsel does not guarantee that the email you just sent to your fellow directors is privileged unless you're seeking legal advice from counsel in that email. And that even if you do request legal advice in the email to a fellow director, with counsel also being on the email, that email will not be privileged if you copy a third party. It's no longer confidential because you just copied a third party. So here's Adam's best advice. Ask a litigator about what the attorney-client privilege is all about. Don't rely on high-quality corporate lawyers like me to give you good advice. That is not their field. And I can't highlight that enough. Litigators, whenever I talk to a litigator about anything in my field, in securities law and corporate governance, they always have a completely different perspective than the people that I talk to on a regular basis. So it's always good once in a while to have a litigator friend that you can bounce things off and get a completely different real world perspective. Let me know what you think.